This is the regularly scheduled meeting of the Municipality of Anchorage Board of Adjustment. Today is May 27, 2015. I'm Baron Cuccio, the chair. Madam Clerk, would you please call the roll?
Baron Cuccio.
Here.
Dwayne Adams.
Here.
Bob Stewart.
Here.
Also present is Julia Tucker, Board Counsel, Amanda Moser, Deputy Municipal Clerk, Lisa Slusner, Municipal Staff Support, and we have a quorum.
Thank you. First thing is we need to look at the agenda for today. I hope you've had a chance to do that. Any additions, deletions, changes you wish to make?
I have no changes.
None. None. I have no changes either, so the agenda stands as written. First item there is the approval of the minutes of the meeting of April 29. And Lisa kindly emailed that to us beforehand, so I'm sure we all have had an opportunity to review that. Are there any changes? Mr. Stewart?
I have no changes.
Well, I can hardly believe that. You're usually very good at spotting spellings and punctuation and things of that nature.
No change.
No changes. I have no changes either. Julia, is there anything that you wish to bring to our attention in a minute?
No, I think that the only thing I had before was corrected.
Oh, good. Any other matter that anyone of you wish to address regarding the minutes? If not, they stand approved, I should say. All right, zipping right along, we need to address briefly Appeal 2015-1, that's the South Anchorage High School appeal. That will be heard by myself as chair, Mr. Stewart, and Mr. Haxby. And we have a new board counsel for that particular matter who is unable to be here on the 24th of June when that is regularly scheduled for. So I had tentatively arranged to meet on the 17th instead. And Mr. Stewart says he is okay with that date. I haven't been able to get a hold of Mr. Haxby, and Lisa, you said you were going to be out of town.
Yes.
So the question is there somebody who can fill in for you, or is this, or what's the protocol? I'm not trying to upset the apple cart here, but.
No, not at all, and definitely somebody could sit in on the meeting. The second piece to it is that there is that pretty comprehensive doing the minutes, and it's a very detailed minute taking. So we would have to have somebody that could do that. And
I'd be happy to do it.
Okay, I didn't know if the nod was enough. I wanted you to say it, but
Lisa's
Amanda,
assistance, I would be
So
happy.
Amanda could do that?
you'll be in town on 6/17. Yeah.
Okay.
Okay.
All right. So it all depends on Mr. Haxby, and as I said, I have not been able to get a hold of him. Hopefully, I will hear from him in the next couple of days. So we will simply have to let that go for a while. It will either be on the 17th, or we need to come up with a different date. My intention is, Julia, and you need to tell me if this is not appropriate, that I simply send emails around and we resolve that issue by email. Can we do that? And we are just setting the hearing date.
Right, I think that either you or in past practice, they've done that through the clerk, has scheduled that. So I think that that's something between you and the clerk. We generally have had the clerk do that to avoid any worry about it being a serial meeting, but I don't know if the clerk offers that support or is able to do that support now. Do you know?
I would be happy to do that, and I do that for other boards, and the way that I do it is send that out and have them reply only back to me.
Oh, good.
And then I can
Okay.
get together, who is available, who's not, and send that on to you.
Okay.
Okay.
Good idea. Have you checked with Barbara on this? Is this okay to do it this way? And
This
I'm
is okay.
concerned about your time.
Yes,
the
and
time
this is
availability to attend to this.
And at this point right now, we're mainly worried about John. And if John doesn't
Right,
come
right.
through, then we'll have to have
Yeah, yeah.
sort of a more elaborate.
Assuming John is available, I will send you a quick note,
Okay.
and then you can send out the official notification.
Okay,
Is that
that'll
the way
work.
we should do this?
Mhm.
Okay, good, that's what we will do. And that, of course, also applies to the adoption date. We need to see how this falls into place. Okay, then, the main item for consideration is item B, 5B, approval and adoption of the findings and decisions of the Board of Adjustment in BOA Appeal 2014-5, Planning and Zoning Commission Resolution 2014-058 for case number 2014-119, GCI DBA AWN conditional use application. You have had Ms. Tucker's proposed findings, and I'm sure you have had some opportunity to go through this. It is a fairly lengthy item, and I think the best way to attend to this would be simply to go through it on a case-by-case basis, unless you have some kind of suggestion of how to address this. So what I'm first looking at is the findings and decisions of the Board of Adjustment of the matter that we considered. And I'm looking at page 1. Are there any changes, additions, deletions concerning page 1? Mr. Stewart.
Based on what we've done with some of the other provisions, do we need to make an adjustment in the
I
preamble?
am not looking at the,
Or you-
I'm looking at our findings. and
Oh, I'm
deci-
sorry, findings.
Yes.
Oh, my mistake.
He's gonna be in this packet if you don't
That's-
have
that's the
the
one.
BOA decision, so.
No,
He's got it.
He's got it.
Okay.
Yeah?
No,
Are there
no
Any
changes.
changes, no changes?
No
Mr.
changes.
Stewart, Mr. Adams?
No change.
How about page 2? Mr. Stewart,
No changes.
Mr. Adams?
No changes.
And then page 3. Any changes, Mr. Stewart?
No changes.
No
Mr.
changes.
Adams? I have a couple minor ones concerning paragraph 9 on top, where it says respectively. Now, I would like to change that word to separately. I believe briefs were filed separately by Heather Nolan, comma. Oh, no, my mistake here. Were filed separately by Heather Nolan, semicolon, and Timothy and Raquel Feller. Does that make sense?
Yes.
Yes.
Okay.
Good
Julia?
change.
I think that's a great change. And so my understanding is for this one, you're just gonna substitute separately for
Yes,
respectively.
that's
Yeah, I
the
think
only
that's
thing
much
I'm
better.
doing there. Regarding paragraph 10, no appeal was filed on the Planning and Zoning Commission's decision. I would like to change the on to regarding. No appeal was filed regarding the Planning and Zoning Commission's decision to grant the conditional use permit. Any problem with those changes?
None.
No?
I'm not sure that regarding is gonna be narrow enough to be accurate.
Okay.
I sort of struggled with that myself, so I'll defer to your judgment, but you all read the appeal, and I'm not so sure that the things that were appealed could be in some way considered in some way regarding the decision to grant the conditional use. So it just depends on how limited
Okay.
and restrictive you want to
I'll-
make that.
I will leave it the way it is. Just leave it the way it is, if you feel that's a better way of doing it.
Well, I wasn't sure, like I
Well-
said, I struggled, I mean, I just,
Yeah, no, that's fine.
I wanted to
And
make
we
sure
want to
that it was
acknowledge the
clear.
struggle.
Yeah.
So we leave it the way it is. All right, I have nothing further regarding page 3. Coming back to that, has that jogged your memories or your ideas about any other changes on page 3, Mr. Stewart?
None.
Mr.
None.
Adams, none? Okay, coming to page 4, any changes? Mr. Stewart?
None.
Mr. Adams?
I've got a couple. First of all, paragraph 14, I think there needs to be a space between approximately and 14, rather minor. Bottom, or same paragraph, last sentence. I think, would it make more sense to say, the Board of Adjustment gave the parties an opportunity to submit a supplemental briefing on the issue of omitted written comments?
Can I have that again?
To submit a,
Supplemental briefing?
yes.
Yes. Sounds fine by me. Mr. Stewart?
Yeah, I think that's much
I
better.
agree.
Ms. Tucker? Is that okay?
Yes, I think that's much
All
better.
right.
Actually.
Any other changes, Mr. Adams?
Paragraph 19, third line in that paragraph. The Board of Adjustment may take official notice of Kate Law. The
Yep.
two is a
Oh,
little confusing to me.
Yep. Thank you.
Okay, thanks.
Anything else?
That's it.
Page 5. Any changes to page 5?
None.
Mr. Stewart?
None.
Mr. Adams?
No.
Page 6. Any changes? Mr. Stewart?
None.
None.
Mr. Adams? None. We're zipping right along here. Page 7. Mr.
I
Stewart?
don't have any.
Mr. Adams?
I wonder on paragraph 32, bottom, where it says, or reducing the minimum separation distance and 200% fall zone. I was wondering if it adds some clarification to insert the words as discussed in 20 AMC 2145-265A 16B. Just as some clarification, and maybe it's not needed.
Discussed in AMC
21.45.265A 16 little b.
was B, not C?
B, C deals with the administrative official.
Oh, okay.
B deals with a 200% issue.
Good. It's fine by me, Mr. Stewart.
No, I think that's a good change.
Ms. Tucker?
Yeah, I think that's fine.
Okay. Any other changes to page 7, Mr. Stewart?
No.
Mr. Adams?
None.
I have none. Page 8. Any changes, Mr. Stewart?
None.
Mr. Adams?
None.
I have no changes. Page 9. Any changes, Mr. Stewart?
None.
Mr. Adams?
None.
Okay. We then come to the attachment, which is the reworked P&Z decision, as it were, reworked by our additions and deletions.
Mr. Chair, as a point
Yes.
of clarification, I sent the reworked one by separate email, and the original unreworked one was attached
Oh, so.
to the decision, and that's because you had wondered in the email as to whether, not finding in the minutes, if whether the changes that you suggested
Okay.
should be made or not. So the one that was attached with the reworked here is just for reference, and the separate one
So-
had your
Yeah.
changes incorporated.
The one with the
Okay.
capital A on it is actually the first draft.
Yes, is the first draft,
the other one is the
because he had
second.
questions
Oh, thank
about
you.
whether,
Okay.
you know,
Then
he
we will-
sort of put things in the alternative, so I wasn't quite sure what
Yeah.
to do there, so I sent it
Yep.
separately,
Thank you.
and Lisa has included them both. One
Yes.
is stapled to the decision, and the other one, as I sent it, with additional eliminations and corrections.
Okay, so then we will work off the one that you sent separately. We all had a chance to review that one. We ready to discuss that? Okay. Let's do it page by page again. You can see what has been deleted and what has been added there. Are there any changes, Mr. Stewart, to page 1?
I think, okay. My question is it appropriate at this point in time to delete part of that heading in accordance with the rest of our actions later on?
And what you're talking about is the phrase, "and denying the
Right.
request to reduce or eliminate the minimum separation distance required by AMC 2140-265A16.
So we'll read multifamily district, generally located, etc.
Yes.
To me, that would be more consistent with what we've done throughout the rest of the findings.
To strike it altogether?
Yes.
Well,
Council?
I think that's a good suggestion. I guess I have the part that I'm trying to figure out, because it is an amended decision, and so you wouldn't want the amended title to say that it's denying the request. And
To
so,
me, it'd be confusing.
right, and I think that that's a very good catch. So my question in there was, we would have multifamily district, and then do we pick up the title for a tower? Do we
Yeah.
pick it up there?
that's what I
Oh.
understood you to say.
Oh, good point.
You're right. It stops after that. There's a period after 265A16.
Right, so we would just stop, we would delete that, and then we would continue.
Right.
Yeah.
So it's a 4-tower in a residential district, generally located within the alley and all that.
Yeah.
Yep.
Okay? Okay, I think that that's a good idea, and the way that this shows, it is as amended by the final decision, and I think that that's totally consistent with your amendment and would assist in eliminating
If I'm
additional
reviewing
confusion.
it on the
Absolutely.
appeal, I would be looking at that and saying, well, why
Absolutely.
did
Say,
we leave
what
that
did they
in?
do that? Yeah.
Yeah. Makes sense to me. Mr. Adams, any comment?
Not regarding that, I think that's a good suggestion.
Okay, all right. Any other changes, Mr. Stewart,
None.
on page 1? Mr. Adams?
Just a question. So this presents basically the planning zoning resolution as amended by us, but there's nothing in here till the very end that says that this went through the process of the Board of Adjustment. And I was wondering, as amended, is it not appropriate to have a whereas that says the case was appealed and heard before no?
My view of the matter is that it wouldn't be appropriate because we are redoing the decision of P&Z. Okay, and so that has nothing to do with the appeal. It says already at the top of it, Planning
As
and Zoning
amended.
Commission Resolution so-and-so as amended by final decision of the Board
Yeah.
of Adjustment, case
Yeah.
2014-5.
Okay.
Okay. So I don't think it should refer to an appeal at all.
Okay.
Ms. Tucker, am I?
Right,
Correct on that?
I think that if you look at the BOA decision that the board just now reviewed, that it goes that way. So
Yes.
on page 9, it has the commission resolution is modified by this decision.
Right.
And so rather than having the tail envelop the dog,
Yeah.
we do it from the dog that way just by tradition, so.
Okay, yeah.
Does that make sense? I mean, it's a good
Question.
I understand where you're coming from, and we try to take care of it just a little bit differently.
Yeah, it's in two places, certainly different.
The only other change I'm wondering about is should it say attachment A on top?
And yes, it should.
It should, right? And how does this work practically for those folks who are not familiar with this? It is now attached to our findings and to our decision as attachment A. Is there a separate one sent to P&Z without the notation of attachment A, or how is this handled practically? Or do they just get our decision with attachment A attached and that's it?
That's it.
Okay, all right.
And they've asked the same question. You may be thinking of, Erica said, well,
Yeah.
if they didn't substitute their judgment, well, she hadn't stayed long enough on that prior
Yeah,
one to know that
yeah.
you had substituted their judgment. But she asked, she says, well, now, do we go back and amend the P&Z
Right.
decision? No, you have the Board
Yeah.
of Adjustment decision that trumps the prior P&Z, and we've made it you've made an attachment there, and it shows as you've been specific to do. It's been handled different ways, but this way seems to work consistently.
And then the department sends this to the parties and makes it part of the case file?
On
Hopefully.
our end, I believe that the clerk's office sends the final decision to the appellants. Is that true?
And the
And-
appellees, presumably.
Mhm. And the
Yes,
appellees.
all parties.
And I think that in the past, you've sent a courtesy copy to the Department of Law, even if they haven't filed a brief, so that they know and are prepared in case there's an appeal. And you've sent it to the planning department, is that correct?
Right.
Okay, I just want to be sure that that continues that way.
Yes.
Because it needs to end up in the file,
Yes.
in the planning department's file. Okay, good, all right. So we are done with page 1. And we now come to page 2. Are there any additions, changes, deletions to page 2? Mr. Stewart,
I have no changes.
Mr. Adams.
Just a question on paragraph 5.
And you're referring to C5, I'm sorry? Just for identification?
A5.
A5.
It's on page 2A5.
E5, I'm sorry. Yes.
Okay, C. So the language in the entry, some commissioners expressed the following concerns of a waiver for separation, etc. And then the concerns is it's in the backyard, there's no separation. And then the wording is the community council voted against opposing the pole extension, which is fact. So that is fact. But that really doesn't reflect what the concern was, which was it didn't gain the support. That was his concern, is he wanted to see the support of the
Yeah,
community
and-
council. And it's just,
And that's why I think we changed it to the wording
Which
exactly what
reflects-
happened,
yeah, and that's,
rather than making a conclusion that the community council did not support.
right.
They voted not.
And that is the fact, that was their action, but that's
Right.
not what was expressed. So I'm just wondering, it just sounds confusing that he expressed that concern, but he did not express a concern that they voted against opposing.
See, I don't believe that was one of the, I don't believe that was a good support test here.
I would agree with that. I'm not in agreement. It's the language and whether.
So what I'm.
I don't have anything better idea. I'd have written something down.
Yeah.
I worked at it hard and came up with nothing
Ms.
better.
Tucker.
So let me say what I'm hearing first. What I'm hearing is two things. The original concern that I believe Mr. Stewart had brought up when we were doing this, which is that the that the manner that this particular concern was expressed in this decision wasn't, it may have been expressed that way, but it was not really a factual way to express it. And what I'm hearing from you is that's correct, but we've left the envelope to be some commissioners express the following concern, and so therefore do we have to stick to the way in which they expressed it, even though factually it's not right?
Correct.
Okay,
That's a good
okay,
summation,
okay,
actually.
okay.
It's just, it was
Okay,
a
so that's what I'm
convoluted
hearing.
way.
Okay.
It was just a very odd, peculiar manner in which it was handled. But that's not our purview
Yeah.
to determine one way or the other.
Okay, so one suggested fix, should I go on?
Go ahead. please.
Would be to have this board do a little further here and just say, instead of saying some commissioners express, just say the following concerns for a waiver of separation from protected land uses found in blah, 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 are noted in the record. And then you don't have to, you're not attributing them.
Got it.
Would that satisfy both of you and be accurate there? In your
Give me
view?
that wording once more. You're
You-
talking about
you
the
would-
preamble to 5.
Right, so you would strike some commissioners expressed,
Okay.
and you would pick up the sentence with capital T, the following concerns, and maybe use a different preposition of concerns on or for a waiver for separation from protected land uses under, instead of found in, AMC 2145-265A16 were noted in the record, or were noted during the P&Z hearing. That's what the record, or were noted.
We're noted.
I think that's good language to me. I mean,
Would satisfy me, and I think it would address.
it addresses my
express,
concern.
Yeah.
Yeah.
Mr. Stewart, how do you feel about
I
that?
think that works.
Okay.
Okay, so should I read it out with the prepositions that I put
Go
in,
ahead.
and then you can decide if I
Please.
pick the right ones? The following concerns for a waiver for separation from protected land uses under AMC 2145-265A16 were noted.
Correct.
A waiver for separation
Okay, let's make that up.
from?
Regarding,
Well, how about the following concerns for a waiver of separation? That's how
Oh.
we've talked about it. So we're just sort of
Yes.
switching those two prepositions. I think that
Yes.
that's a correction that we could have made anyway.
Yep. Okay. Are we all in agreement with that? Any
Mhm.
objection? Seeing none?
None.
Change is made, noted. Anything else on that page?
nothing here.
Page 204, Mr. Stewart?
No.
Nothing? Mr. Adams?
No.
Nothing? Ms. Tucker, anything you wish to bring to our attention regarding page 204?
No, sir.
No? We then come to page 3 of 4. Mr. Stewart, any changes, additions that you wish to make?
No changes. I had some initial consternation about part of that, the item 7, but I've worked through those. That's the right
Okay.
thing to do.
All right. Mr. Adams?
No changes.
Okay. I have a concern that I just want to bring up, and that is that this case started out before P&Z as not only approving the conditional use, but also considering this administrative waiver. And it seems to me that we have done away with that, of course, but shouldn't the amended decision of P and Z make reference to that. Remember, we ruled that it was a mistake of law for P and Z to consider the administrative waiver. And so the question is whether that should be reflected in the reworked decision of P and Z. What we could do, for example, is we could simply add a paragraph, capital D, at the end, that goes something like this. In considering the conditional use, the Commission addressed the issue of proximity of the proposed tower structure to residential structures, and thus separate consideration of that issue under AMC 2145-265 A16C would be inappropriate. In other words, should the reworked decision make some reference to why this was left out altogether? And we need to ask Ms. Tucker, really, what she thinks about that.
I think that my thinking on that would be that needs to be reflected in the Planning and Zoning Board's decision, and to
That's what I'm
where you're
saying. That's where I wish to add it.
Oh, I said planning. I meant
Yeah.
to say Board of Adjustments decision.
It is in there.
Right. And so if it's in there, then I guess I struggle a little bit with attributing it to the Planning and Zoning decision when, I mean, you can
Okay.
subtract things from the Planning and Zoning decision and amend things to be factually correct, but it's sort of the place that you make your ruling is really in your decision, and
Okay.
attach that one
And
as amended, and then it's not that one stands alone after that. It's this, as you said, I mean, here is your whole decision. This one
Right.
doesn't stand alone. If this
Okay.
one was going to be launched off there all by itself, then we would stuff everything that you have in here into that decision.
Okay.
That's sort of my thinking on it.
Yeah, I think that makes sense. Mr.
I
Stewart.
think I look at it a little different,
Mhm.
but in the same vein, is that if I were going to have a change in the decision by P and Z, then what I'd be looking for is something in the record to document it. There'd be nothing in that record, but there would be in the Board of Adjustment record.
Okay. All right, Mr. Adams, any thoughts on the matter?
No, not really.
Okay. All right.
Okay, so I
Should
have
we
one.
just- yeah.
I have one additional.
Well, wait a
follow-up.
minute. Let us just come to closure on my suggestion.
But I have one additional
Basically-
thought on your
Okay.
suggestion before
All
you come
right.
to closure. I think that so I offer this in
Yeah,
counterpoint to that, is that the attachment A could have a paragraph D or a paragraph someplace which acknowledges that, and so it's kind of going back to something that Mr. Adams said earlier. So it would sort of be a combination of what you were talking about and what Mr. Adams said. And so it would be something to the either, and it could even be a whereas. So whereas this decision stands as modified by the Board of Adjustment. So right on the front of it, it says that it's,
Incorporate our record. Yeah.
so there is a back cross-reference that way.
Could I ask another
So-
question? I'm sorry.
well, does that address this issue specifically? Okay.
Yes, to some degree. It still has a signature here for J.A. Ferguson, Chair of the Planning and Zoning Commission. Is he going to sign this?
No.
Okay.
No, this is,
No.
we get it this way, and so we show that they were on it because this is an
Right.
attachment, but they don't go back
Okay.
and, they can't
That's-
yeah, that
readopt
was
it or
my
anything like
Okay,
that.
all right. So you would simply add a paragraph D or whatever we call it, or somewhere saying that this was modified by the Board of Adjustment decision?
Yeah, just say that.
But I thought we already said that that we shouldn't do that.
Says that very thing on top as amended.
Yeah.
I think that I don't think that what you suggested or what you suggested are necessary. It's a matter
Okay.
of preference, and I look to this board to, as with what Mr. Stewart and what we satisfied before, to make sure that your decision represents what you were thinking and is going to be, you are the reality check for what it looks like afterwards. And so if it can be done with clarity and adds clarity, even if it's not necessary, we can do it. If it's a struggle and may not add clarity and is redundant, then we try to avoid it. And so I give you the alternatives, and I look to you for a decision on that.
Well, I think it would be redundant because it already says as amended by final decision. I think that's the answer. And so I think for purposes of clarity, we simply leave it off, and my thought will be put in the wastebasket, as it were. Okay? Anything further regarding our amendment, our reworking of the P&Z decision? Any further comments, Mr. Stewart?
I have
Anything
none.
else? Mr. Adams?
None, thank you.
All right, that takes care of that. And so just for clarification for those of you in attendance here, what will happen is that the few changes that we agreed on will be redone presumably by the clerk's office or by...
I usually do those.
you're
Yeah, I do
usually-
those really
okay,
quick, and
thank
then
you.
I
So
forward
they
it
will be
to the clerk's
redone.
office.
I will then get a phone call
From the clerk's office. 'cause
from
I
the
sent you-
clerk's office that those changes have been made. I will then come down here, review it very quickly. If I find that it comports with what we decided here today, I will sign it. That's the procedure. Okay, coming then to the next item on the agenda, new business. I don't see any new business here. Is there any new business that we're aware of, Mr.
I have none.
Stewart, Mr. Adams, Ms. Tucker? No? Reports. There are no reports. Member comments. There are a couple items here that I would bring up. The first one was that Dwayne sent an email around saying, how come the minutes do not show findings of fact, as he is used to from his days when he was on P&Z and as I was used to when I was on ZIBA for all these 14 years that I was there. Anyway, it simply was that the motion is approved with the findings of John Doe and Jane Doe, who made the comments and supported the decision. And as you saw from Lisa's response, that is not customary here. And it's simply a different way of doing it. I have not seen this before as having included findings, and I'm not inclined to suddenly change the apple cart, I must tell you. That's my thought. That's why the minutes simply reflect the decisions that were made. And if somebody wants to go and find out why the decision was made, then they just need to listen to the discussion. And that's on tape. Those tapes hopefully will not disappear. Anything else regarding this, Mr. Stewart? What's your thought about this?
I don't have anything more on that. I
Okay.
think
All right.
that was a good way of expressing it.
Yeah.
And I'm comfortable with the way we're doing business like
Okay.
this, because it gives us a chance then to go back and look at what we have decided and then digest that, and then when everything comes out of the final findings, then we can look at it and say, okay, are we in the right ballpark? to me,
Yeah.
it's a good check.
I would also add that this being my first case, I wasn't aware that the findings and decision would be as thorough as they are. And so that adds I guess, the explanation that might be usually found in the findings within
Yeah.
the minutes. And so, as you said, the minutes are still available to the public. And
Yeah.
Oh,
On
I would
appeal.
like to say one more thing.
Okay.
Thanks to Julia and thanks to Lisa for doing a good job.
Yeah, few changes with that.
This was very good.
Let's just ask Julia, you've seen this
Mhm.
this exchange of emails regarding the minutes. Are you okay with that?
Right, I guess I would just add just a couple of comments. One is, as you pointed out, sometimes, well, I'll reverse the order of what I was going to say. The clerk takes action minutes. So if there's a particularly important finding that you believe that the board needs to make, then the board makes that and votes on it. And so you're welcome to bring it. So anything that you want reflected in the final and you know you have particular concern about it, then that's the option to do it, and then it will be reflected in the minutes as an important thing. So that's always one option. Sometimes the board will make a series of votes and motions and votes, as they did in this case, and so even though they made them as findings, when it comes to the decision, and I'll give you an example if I can find it quickly. When it comes to the decision, the issue will summarize those. So issue number 4 here on page 5. So to correct a mistake of law in code interpretation evident in the record in the case, shall the Board of Adjustment remand the case to the Planning and Zoning Commission for a full hearing, reverse the decision in whole, or substitute its independent judgment on a matter of law to modify the planning and zoning decision and affirm the conditional use. So that summarized maybe 4 findings or 4 motions that the board made. And so rather than, not every motion that the board made is going to be reflected as a single issue. So there's kind of a balance, there, because you can spend a lot of time being really particular on each one of those motions. And then by the time you finish with the discussion, the importance of those motions in the first half hour of a 4-hour discussion by this board is less important when you finally have your arms around it and get it there. So we just work with a balance. Would you might want to add anything that you have too, Lisa, because I think it's as everybody here recognizes, it's a communal effort here, both in the support of the decision and in getting these sometimes very complicated cases to resolution.
Well, I would reiterate what Julia said in the beginning about if there's something that's important to you, for you to make the motion on it or take a vote so that it is reflected in the record so far as the minutes are concerned. And then that's something that gets highlighted also when Julia does her review to put together the findings. I lost my train of thought on that one. But I think that I'm purposeful when I produce the minutes, and that what I want to do, instead of getting off into the weeds with this discussion took place and back and forth, and then I begin to interpret, what was the intent, or did they mean for this to be important? I don't want to get in that area. So if it's something that's meant to be important, it should be decided by the board that it's important enough for me to reflect in the minutes. And that's where I like that we do action minutes, because then I can reflect directly without interpretation what the board wants is significant to the board.
Okay. Any further discussion regarding this matter?
He raises kind of an aside issue. But I've got a concern that when we have emails, if you have emails that start going back and forth, and then everybody is working an issue on email, to me, that smacks of a...
Remember, at least as long as I've been running this, I've been very careful to make sure that those are not final decisions. These are merely things
Right.
to consider,
These
and
are-
that they
these are
will be brought
considerations.
up at a proper public hearing.
That's why I'm
Or
very
meeting, I
cautious
should say.
about emails
No,
and
it's-
what we do.
And I think we
say
are
that
all
right here.
aware of that issue.
Absolutely.
At least it has come up several times that we cannot make any decision by email, and we certainly shouldn't. So I think that is addressed and taken care of.
That's why I kept a very constrained question with respect to process
Simply
and
a
procedure,
process
not.
question.
Right,
not-
and I
not
think that,
judgment of
I think
anybody.
that the, in my view, where the open meeting and the serial meetings come in is when, as Bob said, when it's not only something that's put forward as sort of notice of something that's going to be discussed at the agenda, what about this change, is meant as a sort of a rhetorical question, because the discussion will happen here. I may do drafting in response to it so that we're all prepared. Where what we really want to avoid, and I haven't experienced it with this board at all, but I've had to caution other clients about it, is when everything goes to reply all, and then it goes to the direction that Bob says, then everybody replies. And so then you have a discussion of all the pros and cons of all these different things,
Yeah,
and then
no,
that's
we can't do
discussion
that.
outside the meeting. And so, as Barron
Yeah.
said, he may copy people as courtesy, but we really discourage
Absolutely.
Yeah.
the response outside of the
Okay.
meeting.
Thank you.
All right. There are a couple more issues I need to bring up. The first one is directed to Lisa, and that concerns the support from the clerk's office. This is a volunteer board, and we don't get paid. We take our own time here. And I'm of the view that the clerk's office needs to provide support necessary for us. Now, I'm not sure to what extent you can do things and to what extent you need to check with Barbara on things, but it would seem to me that, for example, briefs that are filed in cases, they should be either totally run off or not run off at all. But it can't be, it seems to me, and I would like you to discuss this with Barbara, that suddenly some briefs get sent to us on a disc and other parts are printed out. I think the clerk's office should provide us with a printed version. And what brought this to my mind and to my attention was that when I was over here last week, you gave me a disc that had several briefs on it, and one of them was 142 pages long. In looking at this thing, I find that you had already printed a part of it. In other words, you printed part but not all. And so I'm wondering what the policy is, and if you could clarify this with Barbara. It has always been, in the past at least, that we get completed briefs, printed. And we either pick them up or a messenger sends them over or whatever the deal is.
Right.
Okay. And I would like very much that practice to be continued. But you need to check with Barbara on this. I'm aware of time constraints that the clerk's office has, and we're clearly just a little cog in the wheel here. But it seems to me that, considering that we are the volunteers here who are asked to decide these things, that the clerk's office should provide the support that we kind of need, and that involves delivering to us the briefs
Right.
in written form.
Right.
I mean, in printed form.
And that's not a problem at all. In this particular case, we had gotten sort of in the habit of the electronic service of records, and which seemed to be more convenient for all parties. But as it concerns the board, I am always at your service to do what is most convenient for you.
Okay.
In this last one, the ASD, made copies. They asked, they called and asked, how many copies would you like? And, I said I usually ask for 11 to 13 copies.
Yeah.
In the other cases, the other appellees, they filed by email. So I didn't ask, that they deliver copies to the clerk's office. But in trying to send those out electronically, that's where I ran into the hitch, and that's why they ended up on a disc, is because I couldn't send them
Okay.
to you electronically. But in the future, I'm happy to print those. And as it turns out, John Haxby did ask me, can you please print mine and mail them to me, which I did.
Yeah.
So it wasn't a decision made not to do it. It was just,
Okay.
I'm happy to do whatever you want me to do.
Okay, well, I just want to be sure that we don't run into difficulty with Barbara and, so that we are all on the same wavelength. Okay, good. Next thing, I happened to talk to Jerry Weaver and Erica McConnell. I ran into them at some other affair, and I said it would be helpful if P&Z had legal advice in drafting decisions. And both of them rolled their eyes and said, well, that can't be done. And it's mostly a money matter, obviously. They can't contact the city attorney's office and suddenly get charged gazillions of dollars for drafting these things. But what he did say was, he was going to ask, Jerry Weaver that is, was going to ask for funding to conduct training sessions so that those senior planners who are then charged not only with presenting the case, but also with writing up the decision, have some idea of what legally is required to make that a good decision. And so we'll have to see how that works out in the future. Remember, in various cases we have already discussed that, a better job of drafting would either prevent an appeal or at least narrow it down significantly and clarify the decisions of P&Z, and that's what we are after. And so hopefully sometime in the future there will be some relief in that regard. So we'll just have to wait and see. The fact of the matter is that the planning department is woefully understaffed. And, that's what leads to some of these problems, unfortunately. All right. Any other member comments? Mr. Stewart?
None.
Mr. Adams? None? Okay, we then come to the next item on the agenda, and that is audience participation. And I see that there are various members of the community here in attendance, and they may wish to talk to us, but I should caution them that audience participation may not concern adjudicatory matters before the board. When adjudicating an appeal, the board may consider only the material contained in the appeal packet and may not hear argument nor take additional testimony or other evidence. So subject to that caution, is there anybody in the audience who wishes to address us on a matter of general concern, not concerning the specific case that we at length labored on to get the decision on tonight? Anything at all? Feel free to come forward, please. This is not decided. We don't decide things in a vacuum.
Are you all lawyers?
No, we aren't. Two of us are lawyers.
Okay.
And that's Mr. Stewart and myself, and of course Julia Tucker, who is our counsel. But Mr. Adams is a landscape architect. Mr. Haxby, the other board member, is a developer in town. And we are still looking for a fifth member. So if you know of anybody at all who is interested, might be interested in serving on the Board of Adjustment, please forward their names or have them contact the clerk's office regarding an application. Or is it, no, it should go up to the 8th floor, right?
For an appointment?
For an appointment.
For an appointment?
Yeah, there is, the mayor has an assistant on board appointments. And so if you know of anybody who is interested in serving on the Board of Adjustment, he or she needs to contact the mayor's assistant on that. And I don't know who that
It's Stephanie McSwain.
okay. And who that will be after July 1, I have no idea.
Now, normally when you change the decision of the planning and zoning,
Yeah.
normally, and I've talked to someone who's been on the board for a long time, you send it back to them. Why do you decide not to send it back to them?
We have three alternatives. We can either affirm, we can send it back on what's called a remand and say, attend to this or that matter, or alternatively, we can substitute our own judgment and thereby avoid further proceedings before the Planning and Zoning Commission and simply modify their decision. Those three alternatives are given by ordinance. And as you heard, well, preferably we do not send matters back because it simply delays and causes further problems time-wise. Okay? And so the most expeditious manner frequently is to simply modify the decision, which we have the right to do. Okay? So I'm not sure, I've never kept track of the percentage of cases that where we have sent it back on a remand versus cases where we have just modified the decision. I don't know what the track record is there, but it is my preference, generally speaking, to simply modify the decision to expedite the process. Okay. Yes, Ms. Tucker.
The code says that those issues that require further public hearing are going to be remanded. So if it's an issue that the board sees on appeal, that's a legal issue, or something that doesn't involve further public hearing, then those are not the cases that are remanded.
That's a good point. The obvious case for a remand is, hey, you didn't consider X, Y, Z. You should have. You know, you need to reopen the public hearing to consider that particular issue that you omitted. That would be the case for a remand. But generally, P&Z is pretty careful in listening to testimony and considering the packets that are prepared by the planning department, so that overlooking an item is actually fairly rare. I cannot. Wayne, maybe you can remember some that have been sent back for.
I was on the commission for 6 years. We had 2 cases remanded.
Okay.
That's all. And they were pretty narrow perspective.
Yeah.
One of them was about a half-hour thing to address it because it was a procedural error.
Mhm.
We needed to do that. The other one was a little more all-encompassing. I can't remember what it was.
Yeah. Okay.
Very rare, and that was 6 years.
Yeah. Okay. So does that address your concern? Yeah. Okay. Any other comment? Anything at all? All right.
Actually.
Yes.
And if I'm not allowed to say this, please let me know, but this is really very, very frustrating, having read the municipal code regarding these towers, and you guys are just tossing it out 100%.
Well.
And I honestly don't get it, and if I'm not supposed to bring that up, just tell me, but this is so frustrating because it is right out.
Well,
Our doors. I mean, it's
I think
within 34 feet of a couple's house.
I think the only thing that I can say is that when the opinion, once I've signed it and it's available and you presumably will get a copy, hopefully you will understand what led to the decision. But we cannot engage in any discussion of the details of the decision. Okay, I hope you understand. Yeah. Okay. Anything further for the good of the order? Anything at all? Lisa, you have anything else? No? Ms. Tucker?
I'm good, thank you.
Well, thank you very much for coming today, and without further ado, meeting is adjourned.